I was just going, oh, sorry.
Yeah, no, so sorry, go ahead.
Okay, no, I think you put it really well, and I'll just build off of that. I think the comment I was going to make wasn't specifically about the case that you brought up, but just the general tension around strategy with the evidence that's available, and recognizing that in international criminal justice, there is a symbolic element always, because you cannot prosecute every single person that is culpable of international crimes in every single incident. So there will be a selection strategy of who you can prosecute, and there's going to be a symbolic element. But there's a corollary to that as well that I think is very important, which is that if you do charge an international crime without the sufficient evidence and you get an acquittal, that also is very symbolic, and maybe not for the reasons that you would intend. Acquittal doesn't mean that somebody is innocent, but there's a messaging in that, and it could be lack of evidence. So there's always strategy that has to be thought out for the benefit of the victims, for the benefit of the goal, the objective in terms of the International Criminal Justice Project. So I think that tension constantly exists, and going back to James's point, there's always going to have to be a strategy and a priority based on the evidence that's available.
Thank you. I'm here as a Sudanese lawyer, not as a defendant. Not as an accused person, okay. Let me go back to the point that Linda has raised for in the case of Sudan, which is a single case, the first case of crime against humanity, was filed after the revolution, actually, Abu Jega case. The case was, the Court of Appeal said that it wasn't crime against humanity. It was a murder, just a murder. And I think in Wayamo we have discussed that, and we interviewed the lawyer who worked at that case, actually. My viewpoint, and actually the other lawyers also viewpoint in this case, was they prosecute Abu Jega because the political atmosphere at that time was they just need to persecute the former regime, not that they don't know what's crime against humanity, actually. We don't have experience. We don't have, they didn't admit the procedures law. How can they use the evidence in the crime against humanity? Because actually in Sudan, when they put the crime against humanity in Sudanese law, was just for the political purposes in 2009 because of Bashir case in ICC. They just try to avoid holding Bashir or sending Bashir or sending him to the ICC. They just put crime against humanity and war crime in the Sudanese law to say that we have this law in Sudan and we have this crime, so we cannot throw Bashir to the ICC. So, but they forget about, amending or trying to put the way that how can you prove crime against humanity or war crime in Sudanese, which is a big problem now we are facing in Sudan. So that's why for the case that Linda mentioned, the Court of Appeal says simply this is not crime against humanity. It's just a murder, a normal murder. A police officer killed one Sudanese single person who was in the street protesting against Bashir regime. So.
Yeah, thank you very much. I think I just want to reinforce the last two contributions, which bring out the fact that international criminal justice is symbolic in nature, and it only goes for those who bear the highest responsibility. It's therefore not possible to prosecute everyone with international international crimes. And besides, as a prosecutor, I will ask myself, there are different levels of perpetrating international crimes. There are those who bear the highest responsibility, there are those who are middle-level perpetrators, and the foot soldiers. So you cannot, around the foot soldiers and charge them with international crimes. But because we need accountability for all these categories, we leave international criminal law to have its symbolic nature and to go for the big fish. And then for the other fish, we can prosecute them with ordinary crimes. Evelyn Asala.
Evelyn, that was controversial. So I put it to the experts. It's a really interesting point. The standard that the ICC adopts, of course, which is, looking at the most responsible, and I would argue that's a resource issue, not an international law issue, but I'm very curious to hear what the experts say. Is international criminal law solely the domain? Is it only for big fish and the most responsible? Are those the only potential perpetrators or the only potential violators of international criminal law?
No.
Assuredly not. Tadic was a no one. Let's let history decide on that one. But I think the resources argument, on the other hand, is strong. Resources are limited. And if you only have a certain quantity of gold, you are wasting it if you could spend it on somebody high up the tree, and instead of which you prosecute somebody low down. That's bad tactics, it's bad publicity, and it maybe allows the more culpable person to get away with it. So I would agree that there is a symbolism in international criminal law, and as we have been saying over the past 2 days, in fact at previous meetings with other participants over the last week, the International Criminal Court is never going to be a substitute for robust domestic criminal systems. But here you can contrast Kenya and Sudan, it seems to me, and I hope I'm not treading on anybody's toes too much. I mean, Sudan hasn't really got anything approaching a legal system which is in functioning order, whereas Kenya has got a robust capacity and potentially to spare. And with that kind of capacity, it may be argued, come obligations towards the international rule of law to make room in your system to enable countries, particularly perhaps neighboring countries, which through bad luck or bad management or for whatever reasons just can't manage to do what you can do. And that's not a legal argument at all. That's just that's how I feel about it.
Yeah, I might just jump in real quick, James. Just to remind those of you who were here last time, we had a prosecutor from the Netherlands who successfully tried a universal jurisdiction case, and that case was not against the big fish.
Yep.
But there is precedential value we shouldn't look past, right? Getting that first case under your belt, getting all the kinks out, doesn't necessarily need to be with all of the pressure of the world on your shoulders because you've brought someone in here who has political clout, right? I think there's a case to be made that even with small fish, but perpetrators and violators of international criminal law, successfully prosecuting them in this forum, for example, sends a very strong message to the rest of the world that Kenya, again, as we were discussing yesterday, is not open for business for international criminals, right? Yes, go ahead.
I agree with what Ben has said, and there's some other practical observations to make. In Europe at the moment, individuals who maybe, I'm not just sure what their rank is, they're not very senior people, they just happen to be there, are being prosecuted in countries like Germany and France and Sweden. In fact, if I'm not mistaken, the Swedish case I'm thinking about involved a fairly low-level perpetrator who did some terrible things. And so international criminal justice is to some degree opportunistic, even if it's very clean in the sense that it's properly motivated and it's properly supported by evidence. One of the really great challenges I think that the International Criminal Court faced, and I suppose faces, is that it doesn't dwell in the many situations it has in the way that the ICTR or the ICTY did. So when I started out at the ICTR, it never crossed our minds to ask the judges to take judicial notice of the fact of genocide, because we were still ourselves learning what that meant and how you proved such a fact. But down the line, when I came back to the ICTR, I couldn't understand why, with all the trials already under the belt of the judges, they shouldn't take judicial notice of the fact of genocide. And we were successful in an interlocutory appeal in getting the appeals chamber in the Karamera case to tell judges at the trial level that they had to take judicial notice of the fact of genocide. But part of that was a function of dwelling in the situation and dealing with multiple cases. And the ICTY is the same thing. The Special Court for Sierra Leone is the same thing. The ICC is so spread over the globe that it's difficult for it to gain that kind of depth. So you see to date in Mali 2 cases. You know, the most you're dealing with in most situations are 2 cases at the moment. That may change over time. Now you've got 4 arrest warrants outstanding that are public in the case of Ukraine. But this is one of the challenges of international criminal justice, just the pressure on resources. And I think this reinforces the point that Ben was making, that international criminal justice is going to go more and more local. And the capacity of Kenya, for example, to deal with international crimes becomes extremely important in, as Amanda puts it, the International Criminal Justice Project.
Yeah, thank you. I really agree with Mr. Stewart on that last point he made about our domestic systems now being the area in which we are going to expand international criminal justice. I think you all recall that in 2020 the High Court made a decision in the petition that was filed, in the constitutional petition that was filed by COVAO, IMLU, ICJ, and Physicians for Human Rights. And this was on the question of sexual violence that had been perpetrated against there were 8 petitioners. There were 8 people who came forward and made the case that the state failed to protect them. And the issue of what was being litigated was the responsibility of the state. And the orders they sought was that the state was responsible for their protection, and the office of the DPP, who unfortunately was also a respondent, I think you were respondent number 2, failed to investigate and to prosecute. The Police Oversight Authority, I think, was also named as one of the respondents, as were the Attorney General, the Inspector General of Police, the Minister for Medical Services, and the Minister for Public Health, because they failed to provide services to the women who, as Tabitha says, were in their thousands and thousands. Now, the High Court found that actually, under international law, the state has a responsibility to protect, its officials have the responsibility to investigate and to prosecute, and proceeded to award damages to 4 of those petitioners. The Attorney General has appealed that 2020 decision, which came after 13 years. So I wish you well on the Bibi Pendo. It came after 13 years of being in the courts, but it came. And I think that's an important step for us in Kenya, that we got that decision. I think it hits all the right spots in terms of advancing international criminal justice in our own courts. And it's, I think, interesting that the appeal was against the award of damages, not so much the other findings that were made, which I think are extremely important. And for us as Kenya, for us as for you as prosecutors and investigators, I mean, it's something to stand on that this actually came out of our High Court. So I'm waiting to see, I think as we all are, what the Court of Appeal is going to decide on that particular case. And I think that was very, very important. I'm sure you've alluded to it in pleadings on the Baby Pendo case thing.
Yeah, I just wanted to add something on this idea of whether to go for mid-level perpetrators or so-called small fry. And very often, I think it's wrong or it's incorrect to suggest that that's an either-or decision as opposed to a strategic decision. For a very long time at the International Criminal Court, it was seen as an institution that should only be going for the most senior perpetrators. And then with the Mali cases, there was an arrest warrant issued and a surrender of an individual, Almadi, who had been responsible for destroying mausoleums in Timbuktu. Mr. Almadi had agreed to cooperate with the prosecution before he had even been surrendered to the ICC, and did cooperate. And he was a mid-level or perhaps even low-level commander. But he was still, he pled guilty and he was convicted of war crimes and cooperated and helped the prosecution build a subsequent case. And after that, in the ICC's prosecutor's strategic 3-year plan, it actually said we will go after mid-level perpetrators when doing so can help us build cases for more senior level perpetrators. And I think that goes back to a point that we were talking about yesterday, which also is about cost. And if we think about universal jurisdiction cases, as we have today, and we've discussed it yesterday too, if you have a low-level perpetrator, whether it's of a transnational organized crime or an international crime that you think is linked to a wider set of criminality, you should absolutely seek to prosecute them and indeed negotiate with their counsel potentially to see whether they would cooperate in building more senior cases against those who are more responsible for international crimes. And in doing so, that is, I think, not only a strategically wise prosecutorial strategy, but also a resource efficient way to build cases against those who are most responsible. So again, I think this idea that we shouldn't go after mid-level perpetrators is incorrect. It should just be based, that decision should be based within a prosecutorial and indeed a political strategy on building larger cases up that chain of command and seeking to turn some of these individuals and negotiate with them to offer evidence against senior perpetrators.
Are there any other questions or comments? Ooh.
Mr. Stewart. Mr. Stewart. I just wanted to ask you, sir, whether or not the prosecutorial strategy didn't change at the ICC, that in fact, during Fatu's tenure, at some point, the strategy was, in fact, to prosecute lower-ranking officials rather than go for the very top, because they had realized they were not gaining much success in terms of surrender of high-ranking officials of either military or government.
I think it's fair to say that the strategy did change in the way that you have described. The strategy remained to focus on, bad operators who did terrible things, and in some cases, even lower-level people would be worthy of prosecution if what they had done was particularly horrendous. But the notion was building up, starting at mid-level and building up greater cases. The challenge, of course, being what I was mentioning before, the ability to stay within a situation and develop a strategy unique to that situation to work up the chain of command to top levels. That's very challenging, and it takes years in some cases to do. But you're correct. There was a shift in approach. Part of it was opportunistic in a sense, because in Mali it wasn't. It was interceptions by the French who were there of particular individuals who were put on trial, Al-Mahdi and Al-Hassan, as I understand, as I recall it. And I mean, there's so many different situations that arose in this Central African Republic. For example, one of the people on trial now, Ngaisona, has an interest in football. He left Bangui, flew to Paris, and as he got off the plane, he was arrested by French police at the request of the ICC, France being a state party to the Rome Statute. In other situations, of course, it was much more controversial that there was an ICC warrant outstanding and whether or not the state party involved would execute it. But yes, I think generally speaking, what you've described is accurate. Fatou Bensouda was looking to build cases that were solid, well supported by the evidence that would be successful. And part of that strategy was to look to bad operators, but who might be a little bit lower down in the chain of command and more out there and obvious in terms